Good evening, everybody. I hope all of you are doing great. Welcome back to Livelaw Academy. And today we'll be discussing on the DGS question paper, the mains paper from 2023. But this time, this is part two. So if you have not attended the first part, you can refer to our YouTube channel and you will find the first part, wherein I had discussed two important case laws, one for 30 marker, which was related to copyrights, and there was one more which was from the Arbitration Act. So I'll just briefly tell you, so that if you are actually planning to write Delhi Judiciary examination, you must keep this in your mind that a problem based question of this sort can be asked, and accordingly you must be prepared with all these set of questions and accordingly prepare the same. So if just to touch on briefly how the pattern works for this particular exam, we have certain questions. So you will have 20 marker, 30 marker, and 10 marker questions, okay, which will be a total of 200 marks, and the duration will be 3 hours. So you have to accordingly fix your time, accordingly understand that what all is important from a factual question. So for a factual question, you can refer to my previous video, which is from the same exam, that is 2023 exam. Today we have question and answer again, but these questions are very theoretical, okay, theoretical but not per se very direct. So you have application of mind is going to be there. You will have to pick what you really want to utilize and use in that particular answer. So I'll be starting now with the first question. Again, the scheme is that again I have taken one question from IPR and one question from arbitration law, because these are the four questions that I could see from the previous year paper, and I wanted to cover this subject first. So we have our first question. This is a question for 10 marks, okay? And accordingly, you must be, calculatively, you must attempt your answer. We also have a video by Rohit sir, who has attempted and who has shared his idea and his opinion with respect to what all should be there in your answer. See, there's no straight jacket formula as to, if you write this, you'll get full marks, or if you miss on this particular point, you will get only half of the marks. It is the requirement of the question. So when you read a question, you have to understand what do they want, from you. Do they want 2-3 pages long answer for a 10 marker question? Not necessarily. Rather, it has to be qualitative answer and to the point answer. So let's say this is a very simple question, but your understanding of Arbitration Act will be if you have good understanding, it will be very clear to them when you write an answer of this sort for a very straight question, which says that what is the difference between the fifth schedule and the seventh schedule of the Arbitration Act? Please elaborate with appropriate case laws. So here, if you are aware about Arbitration Act, let me just take you through the Arbitration Act for us to understand that what all is there in the fifth and the seventh schedule. I hope that people who are preparing for Delhi Judiciary, they are aware that this is a very important law. So many questions that we attempted from the preliminary examination also in the last video. So you can refer to that video for the preliminary question as well, to get an idea what all is asked and how you are supposed to read this entirely, right? And you must understand also. So with Delhi, it's very important that you are not just mugging up. You do not just mug up that, okay, section 12 talks about this, but you also understand the essence of section 12. So why have I taken section 12 as an example? Because it has something to do with our question. So before we begin, we have two schedules that have been asked here, fifth and the seventh schedule of the Arbitration Act, okay? So if you are preparing for judiciary examination, even though I'm teaching you and telling you about arbitration law, I urge you to know the concept of schedules. Why do we have schedules? So in a law school, we read schedules of Indian Constitution because we understand that they are taught thoroughly, they are part of our syllabus. But at the same time, have you ever questioned yourself as to why do we have schedules in any act, and what is the rule of this schedule? Is it part of the statute? How are we supposed to read it? Will the principle of interpretation apply? Will when you're reading a provision along with the schedule, all these are questions that you must know for a good answer that you intend to write also for your interview exam. Okay, so fifth and seventh schedule are something that relate to the arbitral tribunal. Okay, so if there is an arbitrator, what are the requirements of that particular arbitrator? How do we deal with the arbitrator's impartiality? So when you're writing your answer, if you are clear with the concept of fifth and seventh, you can begin and speak about transparency that is required. See, arbitration as a proceeding is something that parties themselves opt for it and they themselves choose it. So party autonomy, at the same time, whosoever they are trusting, because they are not going to court, so whosoever they are trusting, that particular arbitrator's impartiality is also very, very relevant. The way we speak about principle of natural justice to be applicable in the court proceedings, likewise it should also be applicable to an arbitrator or for the arbitral proceeding. So we have fifth and seventh schedule. Let's just briefly refer to what is fifth and seventh schedule. Okay, and what all do you need to know to write a good answer? So it's a 10 marker, but that does not tell you that you are not supposed to write section 12, or you're not supposed to write the relevant case law, or what is the actual difference between fifth and seventh schedule. So for this we will have to refer to section 4 of the Arbitration Act. We will have to refer to section 12. Specifically we will be referring to 12(1)(b) and 12(5). Very crucial for us to know the distinction between fifth and seventh schedule. And then we can also, in passing reference, we must understand section 13 and 14 as to how challenge is to be done. So when you are appointing an arbitrator, you need him to be impartial, right? How do you feel that in a given factual matrix we can see, or we can apprehend that the arbitrator is not partial, not partial, and he is rather impartial? Those grounds have been laid down under this particular schedule. Okay, so schedule 5, if we go there, you will find that it lays down certain grounds. So schedule 5 specifically read with 12(1)(b). So as I had mentioned over here, that we have 12(1)(b) that we have to read. This is read with schedule 5, and this is read with schedule 7. So had I been a student, a judiciary preparation student, wherein I know that remembering section is also a task. You're not just reading one arbitration act, you have so many laws. So I would just have connected that, okay, 12(5), but it doesn't deals with fifth schedule, rather it deals with the seventh schedule. So that way you can just make up your own small ways of remembering sections. Okay, so either it will come by you reading the law again and again, or it will come by you remembering this sort of things. Okay, so the fifth schedule has to be read with 12(1)(b), and that we will do together. But you see, what does it say? It says that the following grounds give justifiable doubts as to the independence and impartiality of the arbitrator. So whenever there is an arbitrator, if any of the grounds are there with respect to the working of the arbitrator, or with respect to the appointment of the arbitrator, we will have a doubt with his independence and impartiality. Okay, why is independence and impartiality important? Your answer must start with that. So schedule 5 has tried to provide you a list and how many grounds are there. Okay, because fifth and seventh has to be compared. Right now, because I'm teaching you, I am telling you about what all is there. But when you're writing an answer, it has to be crisp. Okay, you must very clearly say that fifth has these many grounds, seventh has these many grounds. What is the position with respect to the same grounds? Now let's try to understand. So I'll just scroll with you for you to get an idea. Fifth has how many grounds? Let's start counting. Okay, how many grounds do you see here? We have 34 grounds. And now if we go to the seventh schedule, this is our seventh schedule. How many grounds do you see? Only and only 19 grounds, and it ends here. So we have 19 grounds in schedule 7. Okay, and how many? 34 grounds in our schedule 5. This is not the catch. The catch is that these 19 grounds lie in schedule 5 as well as schedule 7. Okay, these 19 grounds are common. Let's try to find out how. So we will pick any ground and we'll accordingly cross check. So An arbitrator's relationship with parties in council. Okay, let's go here and go to the fifth schedule and try to find out arbitrator's relationship with parties in council. Even if you read all these ground, these are same. So the question, that is why they are asking you that what is the distinction if 19 grounds are similar in schedule 5 and 7, how do we distinguish, what should be the distinguishing factor? So I'll come to that answer, but for now I have highlighted to you that our fifth schedule and our seventh schedule has almost 19 grounds that are same. Okay, secondly, because this has 34 grounds, therefore we can say that fifth schedule is much more wider as compared to the seventh schedule, which only has 19 grounds. So there are much more grounds that are present with regards to fifth schedule. If you have now, to understand it better, we will have to read it with 12(1)(b). Okay, so if you are somebody who I am thinking to appoint as an arbitrator, what are the requirements? Okay, which schedule will be invoked immediately? First question. Secondly, if you are already an appointed arbitrator for me, then in that situation, I feel after you've been appointed that any of these grounds exist, then what will be the situation? How will we challenge it? What is going to be the ground of challenge, and where do we actually challenge it? These are the questions which will help you write a better answer. Okay, so first thing, that we are talking about the first stage wherein I have decided that I want X person or one of my student to be my arbitrator. Okay, can you be my arbitrator because you are my student? When I say you have a relationship with me, is this a personal relationship, is this a professional relationship, business relationship? All these are discussions that have been done with regards to interpretation of schedule 5 and 7. So we read it now with section 12. We just, when we were referring to the schedule, it clearly says that this particular thing is to be read with the fifth schedule and this is to be read with the seventh schedule. And to highlight, this entire thing has been changed or substituted by in 2016. So the Law Commission of India report had come in 2015. Okay, while you're writing your answers, if you want to stand out, you know, there are so many Law Commission of India report with regards to Arbitration Act. You can always just make a summary. You can prepare your notes. I will take out my piece of paper and I will mention here that this particular report, okay, what does it talk about? So 261st report, what does it talk about? What all important points were, you know, essential in that particular report? You keep your notes that way very clean, so that whatever question is asked, you remember that, okay, this was the report. It will just add quality to your answer. And you just mention that what was so suggested there. So transparency was a ground which was discussed very vividly in 2015, because they realized that you know, there were so many challenges that were being done because of the impartiality of the arbitrator, or you know, that the arbitrator has acted in a biased manner. That is why this has brought a lot of clarity to us as to, and also it is a preventive measure, because here it is preventive. 5 is preventive. Why? Because it is telling you something. Okay, it is expecting the arbitrator to do something. So if you have never read section 12, let's just understand grounds for challenge. Okay, when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances. As I said, I want you to be my arbitrator, so you have to disclose in writing. And this writing also, there is a format, that is what is present in the sixth schedule. So fifth and seventh ke beech mein kya hai? That is the sixth schedule, which talks about that what all do you need to disclose. So when a person is approached, he's supposed to disclose in writing certain circumstances. Now what are these circumstances? Such as the existence of either direct or indirect of any past present relationship. Okay, past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether it is financial, business relationship, professional, or other kind. So very open ended. When we will discuss section 12 in our classes, we will talk about all of this. But for a reference of fifth schedule, we understand that all is this to, you know, this will bring justifiable doubts as to independence and impartiality. If we see all of this is present, it will do what? It will bring justifiable doubt as to the independence and impartiality of that particular arbitrator, first one. Then it says, and very important for previous year, if you refer to the previous year question, a lot of section specific questions are asked. So whether both are important or only either of this situation is important, so you must remember that and has been mentioned here. This is a practice that I suggest all my students to follow, because by this you also understand the law better. So your intention should not only be okay, I have to clear the exam by mugging up. No, if you mug up, you will never remember it, right? So the quality of the answer will be better, especially in a tricky question like this, where you know the essence. That first, this will bring the doubt of impartiality and transparency. Secondly, which are likely to affect his ability to devote sufficient time to the arbitration proceeding. Okay, so we also understand this is also one of the grounds that this is likely that it is going to affect his ability to devote sufficient time and he will not be able to do so. Okay, then all these discretion, all these disclosures have to be made as per the sixth schedule. The performer of sixth schedule has to be followed. And the explanation one says that the ground stated in the fifth schedule shall guide in determining. So if you're trying to understand the law, remember it is a guide. Is it an exhaustive list or is it merely a guide? It is guiding principle for you in determining that these are some situations which we have written in our laws, which are going to be a justifiable doubt for independence and impartiality. So first thing that we have understood so far is that whenever you are you have the prospect of being appointed as an arbitrator, you are supposed to fulfill and write it to them, write it to the parties, that I do not fall in any of the 19 categories mentioned under the fifth schedule. Okay, so there is no justifiable doubt as to my independence and my impartiality. In addition to that, you are also expected that you will not really act in an independent in a in a manner which is going to have raising doubts and with regards to the partiality or impartiality of the parties. Okay, this is where we start first, fifth schedule. Now we come to the sixth schedule. Notwithstanding, this is a little tricky, okay, and you have to be with me to understand this first part. Then we will come and talk about the proviso. So the first part, this is the proviso, so I am highlighting it that this is different, and we will read the importance of this, because this is also going to be an answer in your exam, that how fifth and seventh are different. So notwithstanding any prior agreement to the contrary, okay, if you do not have a prior agreement, any person whose relationship with parties or counsel or subject matter of the dispute, okay, so I'll later highlight also and tell you what all you are supposed to write. But the arbitrator's relationship with the party, with the counsel that is so there, or with respect to the subject matter, or is he interested in the subject matter, all of these are grounds that you have to assess, right? So it says that not any person whose relationship with the party or counsel or the subject matter of the dispute falls under any of the categories specified in the seventh schedule shall be ineligible to be appointed as an arbitrator. So first, that he shall be, okay. Secondly, it says he shall be ineligible to be appointed as an arbitrator, and if it is so present in the seventh schedule. So what are we basically telling you here? That if you are a person who has this sort of relationship which is mentioned under seventh schedule, you will be ineligible to be appointed as an arbitrator. And if you are appointed, how are we going to challenge? We will address that as well. So whatever is mentioned in the 19 categories of schedule 7, it's an absolute bar for you to be appointed as an arbitrator. But then, ma'am, fifth schedule and the seventh schedule both cover the same thing. Both are basically talking about the same 19 factors, and after that maybe 5 has other additional factors as well. So that is where the role of proviso come into picture. Okay, so what does the proviso says? It says, provided that the parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing. What is happening here? Understand. This is where, the overlapping of all the 19 section can be answered. That if after the dispute has arisen between us, okay, not before that, if you have decided, this will not be invoked. If after the dispute has arisen between us, we want to waive the applicability of this subsection. Which subsection? Subsection 5, which talks about the grounds of ineligibility under Schedule 7. They can do so. So party autonomy, coming back to party autonomy, this was not present in the 5th schedule, right? But this is so allowed in the 7th schedule. So if you fall in any of those 19 grounds, you are ineligible. But at the same time, can you waive it off? Yes. At the same time, if you are being appointed as an arbitrator and you fall in any of those 19 categories, are you supposed to write it and tell it to the parties? Yes. So firstly, you have to inform. Secondly, despite of that, if you are appointed, you are ineligible. Thirdly, provided that the parties have not waived off your ineligibility by an express agreement in writing. Okay, so I hope this is clear to you. I'll just write it also for you, all of you, for you to just summarize and to remember that we are saying that these are the 19 grounds that are so there, which are common in the 5th and the 7th schedule. Okay, if you fall in any of these 19 grounds, firstly, as per Schedule 5, you are supposed to inform the parties by putting it in writing. As per Schedule 7, if this happens, if you are there, even though you have written, what is happening? You are ineligible, but you had written it before appointment. Now, after the dispute has arisen, let's say, now can you waive off this ineligibility? Yes. So you can now waive it off by putting it in writing. So this is a ground of party autonomy that we allow under this particular provision, that is section 12 subsection 5 of the Arbitration Act. So 5 and 7, one distinction is this. Then we also spoke of the distinction with respect to where is it to be invoked. 7 is invoked later, 5 is invoked prior to that. And one more important provision is section 4 to understand this. Okay, is there any waiver that can be done for Schedule 5 also, ma'am? Okay, can there be a waiver with respect to Schedule 5? Let's try to understand. Yes, the answer is yes. Now let's try to understand where. This is not a waiver for you to not write, but rather this is a waiver of right to object. So first, if you are being appointed as my arbitrator, you are supposed to follow the mandate of Schedule 5. But if you do not follow that, is it still okay for me to, for me to not challenge it? Yes, provided that I have done what? I have waived my right of objection with regards to impartiality of my arbitrator. Okay, now if you read this, a party who knows that a provision of this part from which the parties may derogate, okay, or any requirement under the arbitration agreement. So this is a requirement. It can be done if it will be considered, it will be deemed to have been waived, provided that if you do not reach to the court, or if you do not really mention, or you do not really state your objection. Okay, so this is also essential section which you must refer in your answer. If very briefly you can just write about the waiver available under section 4, and then you talk about the requirement under 12 clause 5. Okay, I hope this much is clear. Okay, then what is going to be, so this is happening when you are talking about, when we are discussing about while the proceedings are going on. Let's say you find that yes, this particular arbitrator is impartial, or you realize that okay, he has been appointed and he is ineligible. Now you want to contest this. Okay, so this is something that was taken care of, and that was something dealt in this particular case. You must mention this case. This is about the appointment of retired judges. So they, even though they were related, but their relationship was with respect to a subject matter that had come long back, okay, which was not related to the same dispute. So in that sort of a situation, you cannot really say that there is, an impartiality that exists. Also, the court said that this impartiality rather should be falling under Schedule 5 rather than Schedule 7. So let me just tell you that how do you challenge and what is going to be the difference with regards to the challenge procedure. When you talk about challenging of an arbitrator as per Schedule 5, the proceedings of Chapter 3 will begin. So you challenge the procedure, and then accordingly, the AT may accept or deny that, okay, I am not impartial. Now, if he denies, you are supposed to wait for the award to come, and then after that, you can go and you can accordingly challenge it under section 34 of the Arbitration Act. So what am I saying? That if there is impartiality, if there is doubt with regards to impartiality, okay, now when this doubt exists, what are you supposed to do? You are supposed to challenge this. Now, once you challenge, if the AT says that, okay, this is not correct, the ground of impartiality is not correct, now you will have to wait for the arbitral award to come, and therefore later you can go and challenge it under the procedure of section 34 of the Arbitration Act. So I don't know whether you are aware of this entire chronology, but you must know this, okay? So while you're reading this law, while you're preparing this law, just try to see what all nexus exists between all these provisions. So I'll just briefly take you to section 34 that talks about application for setting aside of arbitral award. Okay, so if there is an arbitral award, can we ask it to be set aside? It does not talk about appeal from arbitral award. Okay, so you have to be very clear with respect to that this is a provision specific to setting aside of arbitral award. So if the arbitral award has come and I had my own doubts with regards to Schedule 5, I can go and I can file an application under section 34, but this is not so required when we talk about the fifth schedule. Okay, so fifth schedule provides us remedy under section 14. Let's try to understand how. This is another distinction that you can mention. So we have section 14, wherein we will discuss the second subsection of it. Okay, first, but in context, you must understand what is there in subsection 1. Failure or impossibility to act. So whenever there is an arbitrator, the mandate of an arbitrator shall terminate or he shall be substituted by another if he becomes de jure or de facto unable to perform his function by reason of undue delay. That is one. Or he withdraws from his office. Okay. Now this is the important part. If a controversy concerning any ground referred to in clause 1A still exists, a party may apply to the court to decide on the termination of the mandate. So the party, if the ground still exists, okay, when you talk about Schedule 7, he becomes unable. Okay, he is not, he's by the virtue of law, he's de jure not able to, and he cannot take part in the proceedings. As it said, he becomes ineligible, 12.5. So accordingly, what can happen? The party can apply to the court to decide the termination of the mandate and for him to be substituted, right? So the procedural requirement of fifth and seventh schedule is going to be different, and that is what has been dealt in this particular case as well. So this is how you can write your answer. First, start with the basic concept and basic understanding of what really exists in 12 1B as well as 12.5. Then you discuss about fifth and the seventh schedule. Then you give the idea that why this was important, why the changes have been made after 2015 report. And then you talk about that what are the actual differences between the same. So if even if there is overlapping, the difference still exists. Secondly, the waiver proceedings is going to be different, as well as if you are challenging such an award, that is also going to be different in nature. Okay, so you can mention all of these things in your answer. I believe this should be enough for you to get a brief idea with regards to what really exists in a case wherein you want to challenge the impartiality or the ineligibility of the arbitrator. Okay, all right. So I think we are good with this first question. Yes. Then we move ahead and we talk about our next question. Okay. This is our next question. As I told you, this is about trademark proceedings, wherein we discuss and try to understand that how is this be dealt with. Okay. So the question is, what is the difference between an action for? What is the difference between an action for infringement of a registered trademark and an action for passing off. So they are not asking you that how is a registered trademark different from a unregistered trademark wherein passing off applies. So they are asking you that how is an action, how do you, when you're proceeding for an infringement of a registered trademark, what is going to be your action, and when you talk about passing off, what is going to be your action. So this is the question that we have received. This is also a 10 marker question, so accordingly you are supposed to write. Okay, now before I begin, let me just tell you, we have, firstly we have trademark. Okay, so you must know, and I believe and I am hoping that you know and you have a brief idea about trademark. If not, you must refer to the Trademark Act. Okay, so we'll just quickly open our Trademark Act as well. So we have our Trademark Act here, and there are certain sections that we'll be referring to. For example, we'll be talking about section 29, which talks about the direct infringement of the trademark that so exists. Then we'll talk about section 104. We'll talk about section 135. These are certain provisions that relate to our topic. Okay, so now what is a trademark? First thing, so as when I was giving you the answer for copyright, that question took a lot of time because it was a problem based question. But here if we refer, this is a very straight away question as to what is going to be the action for infringement of a registered versus infringement of a unregistered trademark. So a trademark is supposed to be registered. Why do we need trademark? If I am holding my pen, okay, if I have this pen, I understand that it has a particular trademark. So if I like the experience of writing with Uniball pen, next time I will order or I would want to buy the same pen, right? So this is the concept of trademark, the feeling that you get, the more you associate with that product. So it is important from the consumer as well as the manufacturer perspective that goods or should be distinct from one to another, and for that purpose we have acknowledged and recognized something as trademark. And as I said also, if let's say this is a 10 marker question, so you will have enough of content to write within this ambit. But if it is a 30 marker question, you always and always must start with an introduction where you very briefly touch on the theories of IPR. Okay, IPR was recognized. Why have we recognized something as IPR? Because of those theories. So it is very important, whatever IPR it may be, you must talk about the labor that is so attached or personality theory. All these will give a upliftment to your answer and to your understanding. So when the way I am explaining it to you, to make it very clear, likewise for the reader also it should be very clear, but that does not mean that you waste 40 minutes to write one answer. So crisp to the point answer, but with good qualitative content. Okay, so Trademark Act basically says that if you have a registered trademark, you will have certain set of rights. What are those set of rights? So let's try to understand. And what will happen if there is infringement of a registered trademark? So section 28 talks about the rights conferred by registration. So we understand that there will be certain set of rights that will be conferred to you if you actually obtain a registration. You will have the exclusive right to deal with it. You only can provide a license for it, right? All these set of rights will come with you under section 28. And 29 talks about infringement of a registered trademark. So if you are infringing a registered trademark, it is very clearly so mentioned. But what about an unregistered trademark, right? What will happen when we have an unregistered trademark? So the remedy of passing off will apply. Now, what is passing off? Let me just write here. It is basically a tort. But ma'am, we are talking about Trademark Act and it is a codified law. Why are we studying tort here? So this was recognized as a tort when people used to pass off their goods to somebody else, stating or giving an idea that this belongs to someone else. Let me give you an idea. You must have seen Nike and Nikki. Okay, so there is Nike and there is Nikki. Now, what is the distinction? I am buying a Nike t-shirt for the quality or for the goodwill that they hold or for the brand that I like, right? But I get rather Nikki. So what is somebody who is making a t-shirt? Let's say this person has made a t-shirt. Somebody who has made a t-shirt with this particular logo. What is he trying to do? He is trying to pass it off. He is trying to pass it off as the goods of someone else, that is Nike for us. Okay, so this is the simplest way to understand that passing off is a tort for which there is a remedy that you can get. What all remedies you can get, we will discuss. But now the distinction and passing off comes into picture because we have to recognize unregistered trademark as well. Okay, so the beauty of Trademark Act is that it provides you, it's not like Copyright Act that you have ownership for 60 years. Here you have the ownership for 10 years, and it can, you can continuously renew it, and there are other terms and conditions to that. At the same time, even if your trademark is not registered, there is common law remedy. Okay, so something I hope, also, yes, I will tell you this now itself. If you are attending my class now, or if you're reading it, or if you're preparing for your judiciary examination, very important for you to know the distinction between these two. Okay, your answers and your way of reading of law will absolutely change if you know what is a civil law system, what is a common law system, and which one do we follow. Are we part of civil law, common law, religious law, mixture of all the laws? So you can just maybe Google, you will get a word map wherein you will find a pie chart which will say that blue part is, common law, orange is civil law, and then red is mixture of both. Just try to find out where does India exist. This is important because, see, now in a discussion of trademark, I'm talking about this. You may get a question regarding torts, and if you have clarity with regards to what is the, common law idea, what is the concept behind law of torts being recognized as one of the law, your answers will be very different from other people. So these are certain things that we'll be discussing in our class. But if you are not joining the class, you must know it as a law student or as a judiciary aspirant. So this is a particular remedy that we have recognized by way of common law. So therefore, passing off is not something that we have just now started recognizing, or because it is so present in the statute we are recognizing it. It is a common law remedy, and we accordingly allow the same with respect to unregistered trademark. So if you have a registered trademark, you get certain set of rights. If you have an unregistered trademark, you also get certain set of rights, maybe not similar. The entire procedure of proving that there has been infringement is also different from registered as well as the unregistered trademark. Okay, so the distinction is there, but we acknowledge remedy to both. Okay, so as I just said, section 29 of the Trademark Act you must mention, because this covers the idea of direct infringement. Okay, so there are two sets of infringement that you can mention with regards to a registered trademark. Okay, not an unregistered trademark, only with regards to a registered trademark. One is direct infringement that I have highlighted here. Then we also have indirect infringement by way of contributory violation that you have also done, contributory infringement, or by way of recognizing the principle of vicarious liability. So I'll just very briefly take you also to vicarious liability under this. But these are two ways. So there are two mechanisms. We have direct infringement versus we have indirect infringement. What are indirect infringement? By way of vicarious liability and by way of contributory infringement. And this is specifically on the grounds of section 29. So if you fall in either, let's say, I'll just take a few examples, and then, because we have paucity of time, otherwise when we will deal it in the class, we will read each one of them. Just to get a brief idea as to what is happening here. A registered trademark will be said to be infringed when its identity with the registered trademark and similarity of the goods and services covered by the registered trademark. So when you register your trademark, you register into certain, the classification that is so there, that so exists in the classes of certain goods and services. So if, let's say, I am taking a trademark on Apple, so I take this particular trademark of Apple on electronic gadgets, or maybe later if I want to extend and I want to have a cafeteria also, I will then enroll myself or get classified in that particular class as well. So it's important that it has to be seen. So identity or similarity is there with respect to what? Goods and services. These are different grounds that you can read here. You can pause and you can watch, take a screenshot, or you can refer to the Trademark Act and accordingly find that what all grounds makes a case of direct infringement with regards to registered trademark. We are sticking to our question and we are trying to find out the distinction of action. So a direct infringement occurs when we talk about a registered trademark. Okay. Then we also have indirect infringement, the concept of vicarious liability, because we recognize criminal liability also under trademark violation. So we say that if company has done anything, a trademark violation, it whosoever was the authoritative person will also be held liable along with the company. So what is this? This is the concept of vicarious liability, wherein indirectly we are making you liable for the infringement. And if you have contributed to the infringement, that is another ground. Now, what are the actions for the registered trademark? So there are civil as well as there are criminal action that so exist in this particular case. Okay. What could be the possible civil action that you think will help you if there is trademark violation that is happening? Any answers? What all do you think I would want? If let's say this is my trademark, okay, and somebody else, my competitor, starts using it and he started building a business. Now what all do you think? Firstly, whatever loss has happened to me, I would want damages for that. So just by common sense we will try to find out, and then we will go and refer the provision also. This is section 104, this is section 135. Okay, so we talk about damages because whatever loss has happened, please give that to me, right? Secondly, we can also look for injunction that he has intention of selling these products using my logo. Please, we would want a temporary or a permanent injunction to be imposed on him. Then whatever goods he already has, he has a go down wherein he has put my trademark and he has a lot of goods piled up there. So can I also ask for search and seizure? Yes, search and seizure, as well as we can also ask for destruction that is to be done. In IPR we call them as Areva order as well as Anton pillar order. Okay, so if you want, your answer will look more qualitative if you talk about these set of injunction: Anton pillar injunction or Mareva injunction. So these can be, or there can be, also appointment of a local commissioner for remedying this situation. So these are the grounds with regards to infringement of a registered trademark. If you are suing, or if you are seeking action for a registered trademark, you may expect these set of remedies. Likewise, under criminal law, we allow from 6 months to 3 years of punishment, imprisonment with the fine as well. Now, this is when we are discussing of registered trademark. Coming to unregistered trademark, wherein what happens wherein you are doing not infringement, but rather you are doing passing off. That is why the question very clearly says, it says that an action for infringement of a registered trademark, an action for passing off. It doesn't say an action for a unregistered trademark. So passing off is something very similar to that, wherein if it is an unregistered trademark, you will be committing or you will be doing passing off. Now for passing off proceedings, it is different, right? You will have to prove that firstly you have a reputation. So let's say, think, or do we feel that Bikaner has a reputation, or do you think Bikano has a reputation? So these have reputation, right? Anybody who would hear it can associate and will associate Bikaner with that. So if I open now a Bikaner chai shop, will everybody who's going to visit, they will feel that okay, this is this is the same Bikaner, or maybe this is a branch of Bikaner. So you should have a reputation in the market. Then I am trying to misrepresent you, and or I'm trying to pass off my goods or services from you. And the third one is there must be some injury or loss that has happened to you. So you will have to prove all these three grounds to fall under a case of passing off, or to qualify passing off, which is not so the requirement when we talk about a registered trademark. You only have to say it is a registered trademark. And accordingly, there is a concept of prior use also that is here, that it has been used for a long period of time, people recognize and acknowledge it. All these are grounds that must be available when you're talking about passing off. So this is how you can make a distinction between a registered and unregistered trademark. This is a landmark case with regards to the goods of passing off. Okay, the goods were being passed off. And now if you see the name of the two parties here, Cadila Pharmaceuticals versus Cadillac Healthcare Limited. Somebody, firstly, it phonetically sounds very similar, right? So trademark is not only the name that is there. Trademark can be with any set of mark. It can be a watermark, it can be a sound mark, it can be a smell mark, all these type of marks that we recognize. So likewise, phonetically, it sounds very similar. Then you also narrow it down to the same set of business, healthcare and pharmaceuticals. So somebody who's dealing with one may get an idea that the other one is also belonging to the same person. Okay, we also have this case of the Daler Mehendi entertainment, wherein the toys of the Daler Mehendi were being, introduced in the Indian market from China market, and accordingly, we realized that this can also be considered as violation of the right. So you can write down these two cases, and you can mention this for the distinction. And just to end my class, or to end my this answer to this question, can be that to prove infringement with respect to a registered trademark, it is necessary to show that the infringing mark is identical or deceptively similar. So if I go to section 29, continuously it's talking about that identical and similar, right? But that is not the only requirement when we talk about passing off. In case of a passing off, you will have to show that they are identical and similar, plus this is also been misled, and this is also caused confusion, it was a misrepresentation, and there has been injury also that is done to the party. Okay, so these are 10 markers, 2 questions which you can practice, which you can. So how let me just give you a few tips as to how to make your process of learning and reading easier. Okay, let's say if I am reading any particular topic, or a topic like this, what will I do in such a situation? Firstly, whatever I read, first I read it thoroughly, okay, from book or whatever sources you are referring to. Then I make my own notes, which can be lengthy notes, it can be 2 4 pages notes. And then with my notes, what I tend to do is I will put a sticky note wherein I put all the important pointers. Because for my revision perspective, I will not be able to flip through all 4 pages, and I may miss out on something important. I may not remember the name of the case law. So if you put this in the beginning itself, you will do your revision from here, and mentally you will have a structure of your answer. And this will help you understand also, because if you miss on this particular point, you may not be able to reach her. So the way I just told you that what is trademark, how does trademark work, what is the idea behind trademark, then what are registered trademark, why have we recognized something as an unregistered trademark? Because conventionally this was being used, right? We started recognizing commerce, we started recognizing trade to be done, and in that situation, if you're trying to pass off my goods to somebody else, obviously there is infringement loss that is happening to me. So accordingly, you have to prepare your blocks of understanding, and this will help you during your revision time also. Now, if I have these 10 points regarding my trademark passing off concept, if a passing off question comes, I can write all 10 marker if it is simply a question of passing mark for 20 marks. If a question comes with respect to register trademark as well as passing off, I can definitely divide it and say that, okay, 10 marker, I should be investing 10 marks for this and 10 marks for this. So it will, calculatively, you will be in a better position if you have these points ready with you. So read whatever you are reading, read it thoroughly, understand it thoroughly. You do not need to write everything, but you need to understand it. That has been my intention in attempting this, previous year questions with you. Less likelihood of being asked the same question in DG especially, but high likelihood of being asked the same pattern of question. So when you're reading, and when we will be discussing this in our classes, we will definitely read it in context of all these judiciary examination that are there. So in the last class, when I was talking about list pendants, you will see that there are questions which are very straight away being asked in certain states. On contrary to that, there are other states which ask you, very technical questions, whether list pendants will be applicable at the execution proceedings or not. So both, balance of both is important, because you may be writing the judiciary exam for any of the state. Okay, so with this I would be concluding, and we will meet again. And I hope you all revise, and I hope you all have understood this concept. If you have any doubt, you can definitely drop your questions in the comment box, and I'll be more than happy to answer it later as well. Thank you so much.